Distinction: criminal cases and civil cases. There are distinctions between criminal cases and civil cases. In Nigeria, there are two bodies of law whose purpose is to deter or punish the wrongdoer or to compensate the victim of such wrongful act. Criminal law deals with crime, that is, offense against the state or public or society. Examples are murder, rape, stealing, armed robbery, etc. While civil law deals with a wrongful act that causes injury, loss, or harm to another individual. Examples are breach of contract, tort of defamation, negligence, etc. However, the differences between the criminal and civil cases can be outlined in the following ways. Purpose of the proceedings. Criminal case can be differentiated from civil case based on the purpose of the proceedings. Criminal case is usually instituted in the court purposely to punish the wrongdoer, which means to punish the person who has been convicted by the court, while the civil case is purposely instituted to enable the plaintiff or the claimant to enforce his right and receive damages or compensation for the loss incurred or injury sustained as a result of the wrongful act of the defendant. Settlement of cases. Another distinction between the criminal and civil cases is that criminal cases by nature are not expected to be settled out of court, while civil cases can be settled out of court. Parties involved. Criminal and civil cases can as well be differentiated by the parties that are involved. Criminal cases are usually a case between the state and individual, because crime is an offense against the state, while civil case is usually a case between individual and individual. Legal terminologies. Another distinction between criminal case and civil case is that the terminologies used in the criminal proceedings are not the same with the terminologies used in the civil proceedings. For instance, in the criminal proceedings, the person who instituted a case in the court is called the prosecutor, while in the civil proceedings, the person who instituted a case is called the plaintiff. Initiation of cases. Criminal law and civil law differ with respect to how cases are initiated in the court. In criminal cases, only the federal and state government, through the Attorney General of the Federation or state or police, can initiate a criminal proceeding in the court. A private individual is not permitted to initiate a criminal case in the court without an attorney's fiat, while civil cases can be initiated by private individuals.